So yeah, please do say hi, let us know where you are dialing in from. I know we've got a few HR people that have joined the call as well, because this is a very hot topic at the moment, despite the madness that is going on the other side of the pond. So I'm going to pass you over to Andrea Llewellyn, who is from HR Consulting. She's the founder of the business, and actually Andrea does all our training on the office management courses. So I've got to know her really well over the last year or so, and really I think you're in for, not to put the pressure on Andrea, but a good informative presentation here. So please do make the most of this time, ask as many questions as you wish to. And yeah, I'll hand you over, Andrea.
Brilliant. Thanks, Hannah. So I'm used to Teams, so apologies if I'm a bit slow on responding to any comments or questions that you post. So please bear with me. But obviously, thank you all for joining. Obviously, this is a hot topic in terms of the new duty to prevent sexual harassment. So just to give a brief overview of myself before we dig into the session. So I own ALHR Consulting. So I provide outsourced HR advice and guidance to small businesses, so typically in those tricky employee issues. So think of your disciplinaries, grievances, etc. And I provide that service on a retained or ad hoc basis. Obviously, sexual harassment and the prevention of the new duty is a new hot topic. So Hannah has asked me to deliver a session, and I'm hoping it's going to be really useful for you today. As Hannah said, if you want to put questions in the chat, I'm happy to deal with them as we go through, but there's also a question session at the end as well if you want to save any questions to the end. Okay, so I'll make a start. Okay, so hopefully from the session, you will be able to understand the new legal duty, identify all the reasonable steps, be able to consider what practical steps your organisation could implement, and also understand the risks of not complying with the new legal duty. Okay, so just to confirm, so discrimination laws are actually in the Equality Act 2010. So this law is based around the idea that employees should be treated fairly and equally within the workplace and should be able to work in an environment free from harassment. So the new legal duty came in on the 26th of October 2024, and I'm sure you've seen lots of press and articles around this. And it's the Worker Protection Amendment of Equality Act 2023. So this introduces a new legal duty compelling all employers to show they've taken reasonable steps to prevent sexual harassment in the workplace. So what does reasonable mean? Well, reasonable, if you look at a definition, is defined as either appropriate, fair, or moderate. So what's reasonable for one employer might not be reasonable for another employer. So to give an example, if you're a large corporate employer with big budget, then what's reasonable for you would be to implement quite a lot of things in terms of prevention of sexual harassment. Whereas if you're a smaller employer with a smaller budget and smaller employees, then those reasonable steps might be different. So it's the interpretation of reasonable that's within employment law. So the Act itself doesn't provide examples of what constitutes reasonable steps to prevent sexual harassment. However, the Equality and Human Rights Commission have updated its technical guidance on the steps that employers could take to prevent sexual harassment. So we'll cover those as we go through this session. So if you've already been following updates, you'll know that what the Equality and Human Rights Commission say is that a summary of their guidance is that you should develop and widely communicate a robust anti-harassment policy, including third-party sexual harassment. You should undertake risk assessments to identify where sexual harassment may occur and the steps that will be taken to prevent it. It also states that you should engage with staff through one-to-ones, surveys, and interviews to ensure they're proactively aware of what's happening in the workplace and identify any warning signs. And you should also monitor and evaluate the effectiveness of the actions. So what I'm going to do in this session is cover what you can practically do and implement in your workplace. Okay. So I wanted to first of all cover a few definitions, a few legal definitions, and some examples before we get into these practical steps. So harassment is the best known form of discrimination. So in the legal sense, harassment means unwanted conduct related to a protected characteristic which has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And the relevant protected characteristics for harassment are age, sex, sexual orientation, gender reassignment, religion, belief, race, and disability. And there is also a separate and specific legal section against sexual harassment, which covers conduct of a sexual nature and poor treatment of an employee because they have submitted or rejected conduct of a sexual nature. Sorry, I'm just going to admit somebody into the room. Okay. So in terms of harassment, it's important to note that when considering whether behaviour is harassment, the law doesn't just look at the intent of the harasser, it also looks at the impact of the behaviour on the employee. So behaviour which one person may just see as banter may to the recipient of that behaviour be viewed as unacceptable. So the law looks at the victim's perception, which is what matters most when dealing with harassment claims. Okay, so I just wanted to go through some examples of harassment. I'm sure that many of us have probably experienced them, hopefully long ago, and not in recent years. But if I give some examples, I'm sure that some of them will be familiar to many of you. So some examples of harassment: inappropriate comments. So there's a danger of giving compliments. So this could be where an example of an inappropriate comment is made. So if you give a compliment that is some way linked to a protective characteristic or potentially it's not positively received. So if I give an example, if a male employee makes a comment about a female's employee's dress, say they're wearing a really nice dress that day, and they say, oh, you look good in that dress. That comment, whilst it's intended to be a compliment, there is a risk that it could be viewed as conduct of a sexual nature, and the recipient may be upset with that comment. So that's an example of a type of harassment. General comments and group jokes. I'm sure we've all witnessed some of these. So a person can be a victim of harassment even if they merely overhear a comment or behaviour that isn't really directed at them. So, for example, if we're in a training course and there's both male and female people on the course, but there's a male speaker and he jokes about the role of women, um, the female audience, could be offended by that comment and could potentially claim harassment. So there's an example of where general comments or jokes could be deemed as harassment. Online communication and social media is also another form of an example of harassment. So people tend to communicate more and more through these means now, don't they, in terms of social media, and people share videos and clips which might be funny to some people, but you may not want to share that content, to everybody else. So you need to be really vigilant in terms of what people are sharing on these online communications and social media. And then banter. So workplaces can, I'm sure we're aware, can also develop their own sets of language or banter. And you should also be careful about how it's received and the way it's intended, so it doesn't focus on any protected characteristics. So a good protected characteristic to show in terms of banter is age. So you could have an older employee who's working in your office and, affectionately, he's known in across the office as being the old man. Those comments are made regularly to him, and comments are also passed about how he is slow or how he is out of touch with modern life. And these comments, while they may be intended as friendly banter, as people would call them and refer to them, it could still amount to harassment on the grounds of age. especially if they're going to have a a negative impact on this victim. So if this victim is constantly being told these things and referred to, then that could be deemed as harassment. So what's important is to educate your workforce on these types of harassment, and this will ensure that your workplace is then free from all forms of harassment. Okay, I can see we've got some chat, so I'm just going to omit somebody and check the chat box, so just bear with me. Okay, I think we've covered those, so on to the next slide. Okay, so I've talked about harassment. However, there is now the special status of sexual harassment. So the the Equality and Human Rights Technical Guidance advises that unwanted conduct of a sexual nature includes a range of behaviours. So their technical guidance actually lists these behaviours as examples. So they are sexual comments or jokes, displaying sexual graphic pictures, posters, or photos, suggestive looks, staring or leering, propositions and sexual advances, making promises in return for sexual favours, sexual gestures, intrusive questions about personal life or private life, discussing their own sex life, for example, sexual posts or contact on social media, spreading sexual rumours about a person, sending sexually explicit emails or text messages, and unwelcome touching, hugging, massaging, or kissing. So those are behaviours that are actually detailed in the technical guidance that's out there. Okay, so this is the technical guidance that if you go and search on the internet, you can see this guidance. It's obviously, a huge document. So the purpose of this webinar is to take out the key points of this guidance for you and give you practical guidance in terms of how you can prevent sexual harassment at work. So what I wanted to highlight is in terms of the guidance that they've issued is that it actually includes third parties. So the guidance actually states that employers have a positive legal duty to prevent sexual harassment of their workers. So they must take reasonable steps to prevent sexual harassment of workers in the course of their employment, and that is called the preventative duty. So this includes sexual harassment by third parties. So if we think about third parties, this is people who could come into the workplace, so customers, clients, suppliers, and these third parties could potentially harass your workplace. So it also, the new duty includes the third party element. So this needs to be considered as part of your steps. Okay, so sexual harassment. We are all aware of recent cases in terms of celebrities out there who have been in the press recently, but I wanted to focus on employers and in terms of their examples. So McDonald's, this article here on the left, McDonald's actually was in the news over a year ago in terms of harassment and bullying cases. And then as recently as this month, so in January, they've had new sexual harassment allegations come in as well. What I'll do is I can see there's some chat that's come in, so I'll just go through this slide and then I'll move over to the chat. So bear with me if you popped a question in the chat, I will come to that in a minute. So the sexual harassment allegations that have come in from McDonald's recently, the claims include managers inappropriately touched a worker and customers sexually harassed her. So when she raised it, so when the individual raised this as a complaint, she was told to suck it up. A female worker aged 20 says a male manager sent her topless pictures. And a female worker says a shift manager asked her for sex in return for extra shifts, which she refused. She was 17 and he was in her 30s. So that's quite, shocking to see that a year ago, McDonald's had these cases. They said that they were putting in things to eradicate these things, but yet it's still coming up. So as you can imagine, it's not going to be great for their reputation moving forward. So sorry, I'm just going to move on to the chat because I have seen somebody has posted in there. Right. Okay. Policies we'll get onto in a minute. So someone has asked in the chat if they would combine harassment and sexual harassment. Would you also recommend creating a policy that covers employees or third parties, or would you recommend a separate policy? So the recommendations in the guidance is to have an anti-harassment and bullying policy. So one policy can cover all of those elements. And when we move on to some of the next steps, I'll talk about what policies you might have in your organisation, what you'll need to review and what you can put in there. And we'll also talk about third parties and what you can have for third parties. So, you know, having a separate policy for a third party might be a bit overkill, asking somebody to read, a 5-page document. You might want to review and consider some other options, and we'll discuss this as we move into the link. So hopefully I've answered that question that's come in the chat. I will try and keep my eye on those as they come in as well. So apologies if I missed that initially. Okay. So the technical guidance. So here on the left is the technical guidance. So as you can see, it's, there's a lot of detail there. So at the moment, the Act actually states reasonable steps. However, you're probably aware of the Employment Rights Bill, which is making further changes to the law, and it's proposing to make further changes in terms of harassment to add the word all in terms of positive duty. So what it's proposing is that employees will have to take a duty to take all reasonable steps to prevent sexual harassment of their employees in the course of their employment. It's also proposing to make further changes to introduce regulations specifying what steps are to be regarded as reasonable in relation to the duty to prevent sexual harassment. And it will also introduce employer liability for third-party harassment of employees, not limited to just sexual harassment, where the employer has failed to take all reasonable steps to prevent this. And at the moment, the measures under the Employment Rights Bill, it's not actually known when they will come into place. The Employment Rights Bill has come into place after Labour have come into power. It's their proposals to change certain things, the 28 reforms that they're proposing. And as yet, we don't have a timeline or a date on a lot of the reforms. But what I wanted to highlight and identify here is that there is an 8-step guide here that has been published that helps in terms of thinking about practical steps that you can implement. And these 8 steps are as follows. So they've listed developing an effective policy, engaging your staff, assess and take steps to reduce risk in your workplace, reporting, training, what to do when a harassment complaint is made, and dealing with harassment by third parties. And then number 8, monitor and evaluate your actions. So what I wanted to do is get into those in more detail to give you some practical tips and hints in terms of how you could think about some of these steps which might be appropriate for your workplaces. Okay, so we'll take each of those steps in order. So the first one was policy. So that came out in the chat, sorry. So in terms of having a policy, so obviously it needs to be up to date and you need to refresh it now, given this new duty is out there. So a lot of companies, as I mentioned, will have an anti-harassment and bullying policy. Or you may have an equal opportunities policy, or you may have a diversity and inclusion policy. So you need to go and check what policies you've got which cover discrimination and harassment in your workplace. So check all of the policies that you have. Make sure that they are up to date now with the new duty. So make sure that you cover an element of sexual harassment in there. You cover an element of unwanted conduct, and you also cover third-party assessment. So what you need to detail in your policy is what is the procedure when someone makes a complaint, who's going to deal with the complaint, and what steps are you going to take if it covers third-party harassment. So what steps are you going to take to prevent it? What do people do if they experience it, etc.? And there may also be supporting policies in your organisation that maybe refer to this policy that you might want to refer to and check. So for instance, your disciplinary policy, in your section where it lists gross misconduct, it might describe examples, and sexual harassment might not be in there, and you may want to put it in there moving forward. So that's a policy to review and check. Similarly, your grievance policy, so it'll have a process, you would imagine, or a procedure on how you make complaints. So just check that that aligns with your new updates to your anti-harassment and bullying policy. And you might have some social media policies as well. Or you may be thinking about having a social media policy. So think about adding in things there in terms of sexual harassment and what you would deem as, unwanted conduct and behaviour that you wouldn't expect of your employees. So those are some of the policy areas and steps that you can think of in terms of that reasonable step, practical step. Okay, so the next step that the technical guidance list, so number 2, is engage staff. So communicate your company stance. So this duty has now been released. So what's the company stance? How is the company reacting to this? What do you expect your staff to do in terms of behaviours? Another way to engage staff is to have regular one-to-ones with staff. If you're regularly checking in with staff, you can see if somebody's low, not themselves, or it opens up communication so people can raise things with you, as managers and team leaders, for instance. So make sure that the company stance is out there. Make sure that everybody has access to the policies as well. So do people know where to go to access the policies? Do people know how they can report sexual harassment if it happens, or they're experiencing it or witnessing it in the workplace? And, those one-to-ones as well open up opportunities for people to ask questions and raise any concerns that they have so that you're aware of things. And then you could potentially do a staff survey as well. If you do an annual staff survey, you could include it in the staff survey. So do you know where the anti-harassment and bullying policy is? Do you understand what sexual harassment is? So I'm just going to check in the chat. Here you go. Right, what questions would you ask in a one-to-one meeting and questionnaires, interviews? So in terms of questions to ask, so these questions just come in, sorry. One-to-ones, I would just have it as a regular one-to-one. I wouldn't ask specific questions. It's an opportunity. So having a one-to-one is a good opportunity for you to check in with your staff. And if you're having regular one-to-ones, you'll know how their moods are from if you're having it monthly, for instance, from one month to another. So 1 month, a staff member may come in and they're really, their spirits are high, they're really lifted. I think great, they're in a good mood. And then the next time they come in and they're low, and it's just checking in with people. Are you okay? And it might be that they then open up and say, well, actually, I've witnessed something, or I'm not comfortable with this. So there's not specific questions that I would say add to your regular one-to-ones. It's just a form of checking in with staff so they have an opportunity to raise concerns. And then exit interviews. So questions to add to your exit interviews might be in terms of, were you aware of our policy? Did you experience or see any conduct that made you concerned in the workplace? Those type of questions. So you don't have to ask specific questions. It's more around how you are putting in place your practical steps. So were you aware that the policy covers this, for example? So those could be the kinds of questions you could add in your exit interviews or staff surveys. And it's to go back and check that people are aware and reinforce their understanding in terms of what company stance is in relation to that. So hopefully that answers that question. So number 3 on the checklist as well was to assess risks. So carry out a risk assessment for your workplace. So your risk assessment, I think there's a template available on the portal. So your risk assessment could cover areas and things like if there's a risk, if there's a lack of diversity, in your workforce. So for instance, in the environment that you work in, are all the managers male? All top managers, are they all male? Or is there different elements of diversity that could be a risk in the workplace? Do you have any staff that work alone at night? Do people tend to stay in the office on their own at night, and third parties could potentially be in the workplace as well? So is there a risk there that sexual harassment could take place while somebody's working alone? Do staff have customer-facing duties? So there's another risk in terms of the third-party risk that could be there. Are staff or customers drinking alcohol? Are staff asked to attend social events? So, are those social events where alcohol could be available? So there's a risk in terms of, when people have had a drink, people can get more comfortable and maybe say things that aren't deemed appropriate. And then obviously you could potentially have an allegation of harassment or sexual harassment. So that there's a risk factor. Do staff socialise outside of work? Is there, Friday after work drinks? What happens there? Are there any risks that you could foresee in terms of that? So those are the types of things that you could put in your risk assessment, cover this practical step in terms of preventing the duty. And also think about what reasonable steps and what reasonable risks are appropriate for your workplace. So as I said further, a large corporate organisation with more money, more employees, potentially needs to do more than a smaller employer. So think about the size of your workforce, the nature of your workforce, the cost, the disruption of potentially putting in place factors to mitigate these risks as well. So it all needs to be reasonable in terms of what your workplace is. And think about when you're going to review this risk assessment as well. Keep it alive, keep monitoring it, keep evaluating it. And if you've identified actions to be implemented, when are you going to implement those actions? So are you going to set a deadline? Who's going to review it? Make sure that you're continually thinking about the risks and assessing those. Okay, so I've just seen some questions come in, so I'm just going to go back and look at questions. So night workers working alone, how can we reduce any potential risks of harassment? So if they're working alone on a third party site, for instance, what I would suggest is that you would communicate with your customers, your suppliers, in terms of the behaviours and expectations you expect for when your employees are on that workplace. So that could be one way that you could prevent that risk. You could also have a lone working policy. I know a lot of organisations where people are out working on their own, they have a lone worker policy where employees have somebody who they could phone in. If someone's uncomfortable, the steps that they could do in terms of their if they're feeling uncomfortable in a situation. I'll come on to a bit more onto the third party in the next slide as well, so I don't want to take off the detail here. But yeah, those are some of the things you can do with night workers is, communicate to the clients that they're working with in terms of your expectations for anybody that they're in contact with. That could be one of the ways you could prevent and take a reasonable step. I've got another question here, sorry. How can you reduce the risk of two people in a meeting room? So it's by having your policies in place. It's communicating your policies. It's making people aware that these are the types of behaviours that aren't acceptable. So educating your staff, training your staff. So this is the new duty. We all need to be aware of what is unacceptable conduct in the workplace, educating your staff that this isn't, acceptable moving forward, and what are the consequences of it as well. So if we find that there is evidence that this has taken place, then obviously there's going to be ramifications for that, isn't there, through your disciplinary policy, and an investigation would take place, etc. Okay. So there's another question in the chat. Is there a deadline for when businesses need to have implemented these reasonable steps? There's no deadline in the guidance. The quicker you do it, the quicker you have your defence in place if anything happens. So the duty came out in October. So I would be thinking about putting your steps in place now. So starting your risk assessment, starting reviewing your policy, having those steps in place now, because the sooner you have those steps in place, the quicker you have a defence mechanism in place if a claim was made against you as an employer. Okay. So there's another question here. Can this be added to our whole risk assessment, i.e. the office risk assessment, or does it need a separate one to be made? That's your call in terms of your organisation. So if you're a small organisation and you've got a whole office risk assessment, then you may want to put it into one. Or if you're an organisation where potentially you're going to have a lot of risks, you're going to have a lot of customers that people see on a face-to-face basis. You're going to have a lot of social events. Then it may warrant a separate one. I think it's for you to assess what's reasonable in your organisation. So if you've looked at the risks and there's only a couple of risks, then you may want to just add that to your main office risk assessment, or it may be that you want to do a separate risk assessment. I think it's for you to assess what works for your organisation, but obviously factor the risks. Okay, I'm just going to take a quick drink, so just bear with me, sorry. Okay. So number 4 in the practical steps was to consider, was reporting. So consider using a reporting system. So larger organisations, a lot of large organisations are putting in place a anonymous helpline. And this is either online or a telephone helpline for people to report any incidents of sexual harassment. That potentially isn't an option for smaller employees and workplaces out there. So what you could do instead is make sure that your policy clearly defines and states how people can report any instance they see, and make sure that your policy clearly states what is considered acceptable behaviour, how to recognise sexual harassment. So give people examples of these are the types of behaviour that are not accepted, and also what to do if other people witness it. So if people are witnessing the behaviour, so the examples where there's banter happening and you can see that somebody's uncomfortable, what should they do if they witness that? So all of those key things should be detailed in your policy and communicated to your employees so they're aware, and they're all helping in terms of preventing the risks to your organisation. Record all concerns raised as well. So you might have some concerns that are raised to you formally or off the cuff. So just make a note of all these concerns that are being raised. And this will enable you to assess any potential risks in the future or any trends. So even if people are just raising them informally, keep a log of any comments or concerns that people are raising. Okay. So we'll just move on to the next slide. Okay, so training. I've already mentioned the training as one of the practical steps. So all workers, so you should be including managers, senior staff, and they should be trained on how to identify sexual harassment. So what does it look like in the workplace? What to do if they experience it? What to do if they witness it? And for managers particularly, how should they handle the complaints of sexual harassment? So if they get a complaint, what should they do? What's the next steps, etc. So they need to know how to deal with those complaints. And also, where you've got industries where third-party harassment from customers is more likely, the workers should also be trained on how to address these issues. So from the chat, if you're a lone worker, what steps should you take if you experience any issue where you're uncomfortable or there's unwanted conduct. And also review the effectiveness of your training and offer refresher training regularly. And don't forget to obviously include it in your induction when new employees are being taken on. So think about how you're going to give an overview to new employees when they start with your company in terms of how you're going to prevent sexual harassment. Okay, so complaints is the next step. So number 6. So you need to act promptly when you get a complaint, and you also need to think about protecting the complainant. So if somebody has made a complaint about sexual harassment, it might be quite a sensitive issue. So consider that. That complainant might not want to be in the same area as that person. So you need to think about what they want. as well. So when they're making the complaint, what can the company do to try and protect that complainant as well? Do you need to separate people? Do people need to work from home? It's thinking about separately how you can deal with that complaint and protect people. And you may also need to protect some witnesses as well. So those are things that you'll need to consider. And then obviously you'll need to communicate your outcome as well to a complainant. And as with any formal process within, HR law, you'll need to give people the right to an appeal in terms of the process that's happened, and make sure you're communicating that in a timely manner. Okay, I've just had a question come in, so I'll just have a look at that. We have an anonymous platform where people can make company suggestions. Can this be used for reporting concerns? How we deal with a concern without knowing who it is from and investigating the matter. So generally out there is the helpline that you have about reporting concerns. I think a lot of organisations who have implemented a anonymous sexual harassment line, they would use a separate line for sexual harassment, because obviously it's quite a serious matter. It needs potentially separate investigations. I know there's organisations who have anonymous details, and people can report anonymous issues. But when it comes in, people on those lines are generally trained to deal with things. So they would take details in order to be able to investigate concerns. So yes, the person may be anonymous, but the person on the line would need to explain that they would need to get information in order to, help resolve that issue that they're raising and that concern. So yeah, it's down to how people are trained, and how to deal with that investigation. So taking information from that anonymous person. So I've had an experience of a case where somebody has made an anonymous. It wasn't to do with sexual harassment; it was to do with another grievance. But they reported it through a whistleblowing line. But you do have to get information from them. They don't need to complete their name, but you do have to get information from them and carry out a thorough investigation to make sure that you're, dotting the I's, crossing the T's in terms of dealing with that complaint, etc. Okay, so third party. So obviously that's been highlighted in the guidance. So for third parties, you need to assess those high risk workplaces, so where staff might be left alone with customers. So some of the options and practical steps that you could implement is having signs in your workplace. So those signs could say, in customer facing areas, we don't tolerate any forms of harassment towards our staff. Communicate to your suppliers as well. So say, just to let you know, we are putting in practical steps to prevent harassment in our workplace. These are the expectations of any of your workers that come into our sites. Please ensure your staff are aware of it. And I think somebody mentioned in the chat previously about having a third-party policy. So I would say that you don't need a separate third-party policy, but what you could have is a code of conduct for third parties. So a one-page guide that explains to anyone that's coming on site. So when they sign in, you give them this list of code of conduct, and it says these are the behaviours that we do not expect from third parties towards our workplace. And you list examples of what you deem as unacceptable behaviour, and you ask them to sign, read and sign that. And that's a way of you, you're telling the third party on site what your expectations are. You've got them to sign and read it. So each time you don't have to get somebody to read a full policy, you're asking them to read an overview of your expectations and standards, and they're signing that. And I think somebody has just put something in the chat about that. How do you communicate our policy to one-off visitors who we can't email? Yeah, so one-off visitors, as I said, I would suggest doing like a one-page code of conduct. So when they're signing in as a visitor, you're giving them a copy of this code of conduct, and you're getting them to sign to say that they've read and accepted it. And then that prevents, that gets over the step of you can't email out your internal policy out to other visitors. So that's kind of a practical step in terms of covering off the third party element of that. Okay. And some examples that you can put in that code of conduct would be, we don't accept sexual comments or jokes. Please don't ask our workforce any intrusive questions. These are some of the examples that we wouldn't expect third parties and for our workforce to experience. So that's an example. If you look at your current policy, you may already have those examples there, so you can take your current policy and pull it together in terms of a code of conduct that could be given to a third party. Okay, and then the 8th step in the guidance is to monitor and evaluate. So you've put in place all of these great practical steps now. So obviously you need to monitor and make sure they're effective. And where you've identified risks, have you implemented those changes that will help prevent sexual harassment in the workplace? Is the training sinking in? So if you've delivered a load of training, go back to people, and check that their understanding of the training, is still there. And you may need to go back and review your risk assessment if something's changed in the workplace, for instance. So the technical guidance is, there's a lot of detail out there in terms of the technical guidance. And what it states in relation to taking all reasonable steps to prevent sexual harassment is that an employer will not be liable for harassment committed by a worker in the course of their employment if they can show that they took all reasonable steps to prevent harassment. So this is the reasonable steps defence, which I referred to previously. So an employer will have taken all reasonable steps if there's no further steps that they could have reasonably expected to take. In deciding whether a step is reasonable, an employer should consider its likely effect and whether an alternative step could be more effective. And a tribunal or court may find that it would have been reasonable for the employer to take a certain step, even if that step might not have prevented the act of harassment. So by taking all reasonable steps that you can, that's reasonable for your workplace, you have your reasonable steps defence against claims that could potentially be made against the workplace. Okay, so some of the risks of not complying, with the new duty is liability. So individual employees as well as the employer can be held liable for sexual harassment under the Equality Act 2010, put my teeth in. So where there's been an incident of sexual harassment and a claim is brought in an employment tribunal, an employer can be held vicariously liability for the acts of its employees. So vicarious liability means that an employer can be held liable for the wrongful acts committed by their employees if those acts occur within the scope of their employment. So to defend it, an employer will be able to show that it took reasonable steps to prevent sexual harassment. So you've gone through those 8 suggested guidance steps, and if you've got all of those in place, that's your reasonable defence from vicarious liability. So I've just put in on the slide here as well the figures from some harassment claims last year. So they average from 35.2k to 58.7k. So that's some of the exposure in terms of risks of harassment claims in employment tribunals. And obviously, since the new duty, employers are now also liable for failing to take steps to prevent sexual harassment. And this can increase your compensation award by up to 25%. So if you're failing to take those practical steps and implementing further steps to help reduce the risk in your workplace, if you had a claim, then your claim could increase by up to 25%. So an individual can't bring a claim to the EHRC, which has the power to take enforcement action against an employer, but it can take enforcement action. So that will include investigation, issuing an unlawful notice to the employer, entering formal legal binding agreements, or asking for a court injunction. And then obviously there's other risks to the employer as well. So, if people are being harassed at work, there's risks that they could bring in terms of health and safety at work. You're not making their workplace safe for them. An employee could resign and claim constructive unfair dismissal because you haven't put in place measures to protect them. Obviously, I've given you an example of McDonald's and what's happening to them at the moment in terms of harassment cases. So their reputation will be tarnished in terms of that. And then, as I said, the EHRC has the power to take the enforcement action against the employer as well. Okay. Just check if there's any more questions in the chat. I can't see any further questions. So just to summarise some key points as we're wrapping up and getting towards the end of the session. So educate your workers on the types of harassment to ensure the workplace is free from all forms of harassment. So this is all types of workers. So if you've got 0 hours contracts, casual, permanent, make sure that all workers know that what the types of harassment are and what you will not accept as those types of behaviour in your workplace. The new duty, so this compels all employers to show it has taken reasonable steps to prevent sexual harassment. So this includes third parties. So act now, so start implementing these practical steps so that you have your reasonable steps defence in place, and monitor and review those practical steps. So once you've put them in place, are they working? Do you need to do more? Continue review, and the Employment Rights Bill is down the line, in the next year or so. So we may have to implement more depending on what comes out of that bill as well. Okay. So last slide in the session. So any questions? I've seen a couple that have come through in the chat, so I'll just go over to those. And I've also just put the legal duty summary at the top there just to remind you. So just going to go over to the chat and just check. Question. Okay. So the question is, for third parties, when employees travel abroad, for example, to conferences, how could we cover this when typically they would not be able to hand external party clients a code of conduct document? Yeah, potentially they couldn't, but you could advise your external party ahead of the visit that you have expectations in terms of their behaviour towards your workers. So that's one way of covering it, rather than taking a code of conduct document over to them. It's telling your clients and your customers to let you know we are doing these steps to prevent sexual harassment. If we have communications, we wouldn't expect your workforce to display any of these behaviours towards our workforce. Okay, another question has just come in. Is it necessary to provide training? I've had a few offers for paid training from external parties. It's one of the practical steps that's in the guidance as reasonable defence. So as it's there in the guidance, I would consider doing a training session. A lot of external parties are offering training. I'm offering training as well as an off-the-shelf package where you can go through. So I think it's worthwhile, even if you're just refreshing people in terms of, this is what our policy says, this is, unwanted conduct, and these are examples of sexual harassment. Please be aware this is where you need to report, etc. So I think you do need to refresh people in terms of the new duty, and a lot of employees aren't aware of it. I see a lot of other parents. I've got a daughter who goes to football. I speak to other parents, and they mention things in their workplace. And I had one of the parents came up to me, and he obviously knows I work in HR, and said, "Oh, we've had all these posters have gone up in the workplace about sexual harassment and reporting lines, and we think that something's happened. Why have they suddenly started putting these posters up?" And that's because they haven't communicated well. We've now got a new legal duty, and we need to ensure that we're putting steps in to prevent things, and people know where to report it. The workforce have gone off on a different tangent and totally thought, oh, something's happened, and we need to be worried? Do we need to be scared? So I think that communication and training will help in terms of landing that message and potentially not giving off an incorrect signal to employees. Okay, I'm just going to check another couple of questions. Okay, is it necessary to provide training? Yeah, sorry, no, we've seen that one. Is there any other questions before we conclude? I think we've got a few more minutes left in the session. I think I've covered all of the questions. I think I've covered most of all the questions that have come in. If I haven't, please shout or raise your hand.
Thank you so much, Andrea. Just while we give everyone a minute, just in case there are any more. Hopefully that was helpful for everyone. Please do feel free to use the chat if you want to thank Andrea or ask any questions publicly in there if you don't want to direct message her or me to ask them. Andrea's details are obviously on the screen as well. So if you want to find out more about that training package that she's put together, she has shared that on the portal. I think there was quite a lengthy thread about training on there. So you can either look there or just drop Andrea a line and she can share the information and resources with you. So yeah, hopefully that's been helpful. Thank you so much, and we will see you all very soon. Thank you, Andrea.
Okay, no problem. Thank you.
Appreciate it. Thank you.